welcome to UNG PSSA's weekly CrossRoad meetings. Today's supposed to be a special Constitution Day CrossRoad. This is an event that we host annually for our club and for the school. It's sponsored by the the Constitution Day Committee here at UNG, who meets up annually. I've just recently learned every summer to discuss plans going forward throughout the fall. But if y'all are unaware, there is a new Hawk the Vote initiative that's spanning all 5 UNG campuses, and this is a big push from the Georgia State Legislature to try to get people our age involved in voting, or at least politically conscious. So you may be hearing about events from one organization or another, and it may be all confusing for you. We're trying our hardest as a team, just not students, but faculty and also beyond with other departments, to try to figure out how to make this a little bit more clear. But today is Constitution Day, and yesterday was National Voter Registration Day. If you don't know, you need to get your voter registration completed by October 7th in order to vote in these upcoming 2024 general elections. We as a team are creating a student digital voter guide accompanied with a more in-depth printed voter guide, which we've done in the past, but we hope that this serves as an opportunity for students to not only, feel like a part of our team as the PSSA, but also as a community abroad in Georgia or in the various districts of UNG campuses. So without further ado, today is Constitution Day, and this is pretty atypical to how it's happened in previous years, but I hope that it's another successful meeting.
Okay, so we're going to talk about the Constitution today, and I wanted to get us started with a little bit about the Constitution and sort of put it into context to talk about, why we came up with what we came up with, and then we can talk about where we go from there. Of course, following our declaring independence, we had to come up with something. We had to figure out what we were going to do. The goal of the revolution was really independence. It wasn't necessarily unity, but unity was pretty much required to prosecute the war. And so once we declared independence and successfully completed the war, more and more people began to think about that idea of union. And so we began, of course, with the Articles of Confederation, which were a disaster. But that makes sense. Believe it or not, that makes sense. They were awful. They were way too weak. They did not provide for most of the things you need to run a unified government. And so you had states fighting with one another, competition, you had confusion, different states used different monetary systems, and so it was just a total disaster. But again, that makes sense because we declared independence because we wanted to get away from a heavy-handed, distant British government, and we thought it was too autocratic, too heavy-handed. And so the analogy that I use in my classes, and those of you that have been in my classes before might recognize the pendulum that I often talk about. The British government was very, very autocratic and oppressive, at least to us. And so when we declared independence, we wanted to get as far away from that as possible. And so we created these Articles of Confederation and made them as weak as possible, so that this was the United States was something more akin to a United Nations or a League of Nations rather than a unified country. And again, it didn't work. Alexander Hamilton described it as the last stages of national humiliation. Okay, and so we set about to create this Constitution, and they began to realize they had to swing the pendulum back. But they didn't want to go all the way back. So they're trying to find this happy medium in the middle. And so they wanted a stronger national government, but because of their experience with the British government, they feared a strong central government. And so they tried to build in all sorts of safeguards, separation of powers, checks and balances, so that no one group could operate without others, so that the president could not act completely independently, the Congress could not act completely independently, the judiciary could not act completely independently. And so they created this system of checks and balances, right?
I said that's all different now.
As well, I mean, it certainly has evolved over time. And so that was their thinking. Their thinking was compromise. Their thinking was that pendulum. We don't want to go all the way back to the British government. The Articles of Confederation were a failure. We have to go back somewhere in the middle. Now, the story doesn't necessarily end right there, because when they presented their new constitution to the public said, no way. Okay, we rejected it. We thought it was going too far back towards an autocratic central government. And we demanded more explicit statements of the rights of individuals. And so, to make a long story short, the framers, who thought they had done something wonderful, were kind of taken aback by this criticism of the public and this refusal to accept the Constitution by the public, and they conceded, okay, if we add a few amendments to our original design, maybe we can placate the public enough that they will accept the Constitution. And those amendments became the first 10 amendments to the Constitution, the Bill of Rights, which focused much more on limiting government. So the public thought we had gone too far back in this direction. The Bill of Rights pushes us a little bit further back in this direction, but we didn't want to go to the extremes in either way. And so that's how we wound up with the basic Constitution that we have in effect today. And of course, it has evolved over the years. It has changed over the years. There is a provision to amend it. There are far fewer amendments than anybody had thought would happen. But it certainly has changed, and changed in fundamental ways, which we can talk about in our discussion today, most notably the 14th Amendment, which some people have described as a second constitution. So with that in mind, let's talk about it. Did the framers get it right? Has it changed too much over time? What are your thoughts about it? Go ahead.
Just because like it is a politically polarized time right now, I always like to start like talking about the Constitution with, because we're in America, it has to have worked or in some way, shape, or form to have been such an old document that's still functioning to this day. The fact that you're able to amend the Constitution is a unique privilege that we have in this country. And there's different ways that you can go about it, but yeah, just to start off to answer your question, I think what the framers intended obviously was not for this interference of parties, I guess, as a new form of like public opinion. I mean, you can see like there were some elitist ideology and like some qualifications to be representatives or senators. So you can tell that they kind of thought, you know, the political establishment was one of, I guess, a higher calling. And the House of Representatives was treated more of just like, you know, your layman who's trying to help push things as fast as possible to, you know, please his people, the whole idea of the electoral connection. So I think that the Constitution in itself was like very benevolent. It was entitled, like it was set out to be like the greatest secure of liberties and freedoms in the current time. But as we've seen like over time, there's just been like certain things that they couldn't have expected that some people have like started to take advantage of.
Okay, before we go ahead, we have a statement from a viewer, which points out that one of the failures of the Articles was brought home by an incident known as Shays' Rebellion, which many of you should probably know from your American history, which was a rebellion of debtor farmers against creditor landowners and property owners, et cetera, and it was the inability to manage that crisis that was one of the flashpoints in abandoning the Articles of Confederation and trying to adopt something different. We also have a statement here about the Constitution that it has changed a lot. We had an amendment that was in place and we changed it. That was regarding prohibition. So we've actually changed at least that instance back and forth, prohibiting the sale of alcohol and then going back on that and changing it. So it has changed in multiple directions at one time or another. Go ahead.
Oh yeah, and it's showing its age more, even aside from just the political angle, but also the technological angle. For example, you've had a lot of debates regarding in the last even 0 to 10, 20, 30 years about how we should deal legally with issues related to technology. As in the modern day, we might think of stuff like generative AI or deep fakes and so on. And so it's difficult to see the interaction with that, because obviously people writing this up in the 18th century, they could not have foreseen any of this. And even if there are, or even flaws aside that it had when it was made, there's still that difficulty in trying to connect that, or a document that's almost 200 years old, to the modern day.
Yeah, and there's this like whole idea like we have in the Bill of Rights of like negative rights and the positive rights, like what can the government do, what can they not do, and it's going to change as times evolve. But the entire idea of like what the Constitution was originally intended and written for, a lot of these guys were inspired by philosophers like Locke or economists like Adam Smith. And so if you take the US Constitution and you try to make it too, I guess, prescriptive, then I can see what like Dr. Cavalli's saying about leaning more on the line of like authoritarian rule, because like the point of the Constitution was to try to secure the freedoms of as many, it was kind of like a utilitarian approach almost, like as many people for the like common good of society, like allow people to be individuals. And I don't know, this whole individualistic like take, like the United States, this approach that we have in our culture, it's kind of like starts all the way back from like when it was written, and we can even see it in the 13th, 14th, and 15th. That's just furthering and extending these rights which are inalienable, and like this idea of inalienable rights and like under a creator, like these are things that the founding fathers genuinely thought like, hey, we can't guess the future, so let's just keep it broad for now. And that's the idea of these amendments. For prohibition, for example, like there was the temperance movement, like men were beating their wives, like, and they were getting blackout drunk and not being able to perform at work. It was irresponsible for the government to allow this to just like affect so many people in their nations. And so then they realized like, holy crap, like it's not like just the alcohol that's the issue. There's like a cultural thing here. So like that's kind of hard to write down in one law. And so like they had to go back on it. So I don't think the Constitution is meant to necessarily give too much power to the government, and in that particular instance, I think that it's done a good job.
Okay, we have a comment over here.
Yeah, about like the Constitution, I think, I believe it was you that mentioned like the sort of the fact that's kind of outdated, and I agree with you. I think, well, it depends on what framer you're talking to, because Thomas Jefferson, I think he wanted the Constitution to change like every 20 years.
He thought there would be hundreds of amendments.
Yes, exactly. Yeah. You know, he wanted it to change sort of, I think every 20 years or so to fit. I think what he said, the generation that can express the most happiness or bring forth the most happiness. And I think James Madison disagreed with him and wanted to stay kind of this vague sort of absolute document. But I think with this debate, I think the Constitution should change and should evolve throughout generations. I think if we kind of hold on to some of these older sort of rules and amendments and sort of articles, it kind of holds us back a lot. Every single election cycle, we always argue about the second article of the Constitution. Should we reform the Electoral College? Should we get rid of it? Should it be popular? And now we're kind of, we're not, the Constitution was made during a time which, you could only vote for your representative. Now you can vote for a representative or senator, and basically all of Congress. So, I mean, yeah, I mean, I think it should change in big ways towards,
Now, one of the things that I talk about in my classes is flexibility in the Constitution. There is an amendment process to actually make changes to the Constitution, and we've had some, but far fewer than many of the framers had anticipated. But that's only one way. I think one of the reasons that there haven't been more amendments is that we've actually been able to get around that. We've been able to adapt without having to amend the Constitution.
You said to adapt. I feel like I wouldn't say we adapted as much as we are limping through, because like one thing that I feel like the Constitution just sort of exacerbates is the subject of state versus federal powers, and so naturally that's been a problem since the beginning. Now it's a huge problem with things like abortion, gay marriage, drug use, so on and so forth. And so I feel like the biggest problem is that we really don't have a clear line, if that makes sense.
Okay.
Yeah, well, she brought up the idea of federalism and like state powers and the federal powers, and like, in my opinion, that's one of my favorite like topics when it comes to the Constitution. I really do think after I had done an internship at the state capitol, and I realized like, oh my goodness, like these are the people that are helping me on my day to day. It really put it into a bigger, like a greater perspective for me on like the roles that each of them play in our specific like political system here in the United States. And I see it as being something that could be like advantageous for our country, but it's very unique, and I don't think any other nation can exactly copy us and try to replicate what we do. That's why I think when we talk about change to the Constitution, it's important to like distinct between reform, amending, or entirely just getting rid of it and establishing a new one. And I don't necessarily think that the United States needs to do that entirely.
I agree that for a document that is so old, as one of the longest standing democracies, it's like incredible how well it's aged and how it's been able to at least somewhat keep up. I do agree there are parts that are, let's say, maybe that we just don't use anymore. We could say like the Third Amendment, that's pretty irrelevant to us, but it's still there, and we can, move past it and use the parts that still do apply to us. I think that like our founding fathers couldn't have predicted maybe incorporation, but incorporation has managed to maybe like double secure or like double down on rights that we already have. And I won't speak on it much because I'm sure somebody else maybe knows more
Just
than
to
I
explain, incorporation is bringing the states into the federal Constitution. I mentioned the 14th Amendment before. That's one of the major features of the 14th Amendment was to say, and the interesting thing about that is that it sounds really odd to us today. But this was a big question 150 years ago. Do the states have to follow the federal Constitution? If the federal Constitution guarantees us freedom of speech, says Congress shall make no law, does that mean it's limited to Congress? Does that mean states can limit your speech or throw you in prison for what you say? The 14th Amendment, at least in theory, changed that. But we didn't, no sooner did we adopt the 14th Amendment than we essentially ignored for several decades its existence and we went about our lives as if the 14th Amendment didn't exist. But over the years, through many of those incorporation cases to the Supreme Court, we have incorporated the First Amendment, we have incorporated the Fifth Amendment, we have incorporated various amendments and various parts of various amendments into the Constitution, saying states have to follow this, but it's still an issue to this day. The Second Amendment was not incorporated until just a decade ago. And so that notion that the states are actually bound by the U.S. Constitution was a big question. Actually, I want to mention one quick thing that I forgot to mention. Any of you who are newcomers here, I will be passing around an attendance sheet to document your attendance here. You can put a faculty name next to it. If you do, I will contact that faculty member verifying your attendance. I can't guarantee they'll do anything about it. Hopefully you'll get extra credit, but I will be passing this around, so you wanted to say something.
Well, yeah, and a little bit more on the flexibility of the Constitution, as you were talking about, where even though it was written a long time ago, we have seen that the Constitution has sort of kept up with times in one sense in its interpretation. And you see this especially in Supreme Court cases where people argue regarding either the letter of the Constitution or the spirit of the Constitution. And at once, that is an advantage because that allows us to keep it as sort of a living document in a way. But that's also been a source of much friction. For example, with the Second Amendment, where people argue about, yes, literally, the Second Amendment allows so on, but the Second Amendment was written at a time where guns were like much more different compared to today, where we have something like machine guns and AK-47s and rifles.
Somebody else? Yeah. Go ahead.
I was going to mention, like, we've kind of invented another way to evolve the Constitution through the Supreme Court, as you said, because, like, we didn't really intend for them to really be the people interpreting the Constitution, but they kind of evolved into it really early on, and it kind of helped out where in current times, I think, in things like, you know, just figuring out, oh, this is what they meant, or this is what we will interpret it as meaning in this context.
Well, that's part of that. Yeah, actually, that's part of that flexibility that I was talking about. Is that the words of the Constitution are open to changing interpretation as life goes on. One of the things I point out in my classes is that one word in the Constitution has been a major source of interpretation with monumental effects for the distribution of power, and that's the word commerce. The Constitution contains a commerce clause in it that says Congress can regulate commerce between the states. But the definition of commerce initially was thought to mean only the actual movement of goods and services across state borders. It was not until the 1930s, the late 1930s, in what was known, characterizing the Supreme Court, or what was known then as the switch in time that saved nine, the Supreme Court suddenly started interpreting the Commerce Clause much more broadly, saying that, oh, well, now we think commerce is not just the actual movement of goods and services across state lines, but also the working conditions in the places that produce goods and services. And the rules and regulations around workplace safety and child labor. And suddenly they thought that that was included in interstate commerce. And including those things gives much greater power to the federal government.
Because like the reasons you outlined just now, literally, I think that the Supreme Court kind of was intended to be another check or balance, obviously, on the other two branches, and the power of judicial review and the inspirations from French and British law make it so like case law can actually impact our Constitution and what we're allowed to do. So like when, I don't know, I think one of the points you had made was it's kind of like evolved into this thing. I think it was kind of intended always for that purpose, and it's the like how people have been using that power has changed.
Well, I meant it sort of more like, because it started so early on, now we think it's so natural and that it was kind of intentional, because the founders were still alive when judicial review was started, but they didn't write it into anything. It wasn't part of it, part of the Constitution. It wasn't in any documents. It was just kind of the thing that just kind of started.
As the supreme law of the land, I mean, isn't it outlined like the Supreme Court's job in Article 3 or 4 of the Constitution? Is that not the entire purpose of that section?
There is a supremacy clause.
The supremacy clause, yeah, but it was like,
and I feel like
it was more of a specific thing of the Supreme Court, you know, will look at this case and use that case to interpret this part of the Constitution.
Yeah,
And
well, I think it's like backwards. Like they'll use this part of the Constitution to
Yeah.
interpret
Yeah.
if this legislation is constitutional or not.
Yeah.
And that's like in itself a great power that they've always had.
yeah, it's just when it always, the way it was explained to me like in classes though, was like, it was, the Supreme Court was seen as weak. It didn't really do a lot except being, like the final say on
Yeah, I think
court
that they
case.
didn't do a lot, but I think that they always could have if they wanted to. Like they,
Yeah.
like they
And
talk
that's
about
where
legislative
judicial review came
supremacy.
from.
Like imagine if the Supreme Court just did, like a lot of people are concerned with when it starts to become politicized or nationalized. Like people are starting to care about which parties the judiciaries are because they're lifelong terms, and like I get that's a genuine concern for a lot of people because they do have a lot of power. They just never use it, and it's because like, in my opinion, these Supreme Court justices, because it's a lifelong term, we usually pick some pretty smart people. We don't just pick like silly Willy. So that's just my opinion.
Sometimes we do.
Did you want to?
If you're talking more about directly on that topic, you can go ahead. Okay. I am glad that you brought up judicial review, though. Or like clarified, because I wasn't sure that that was something that was introduced at the time of the Constitution we created. But I think another reason why it's worked so well is the full faith and credit clause. Yeah.
Which, just to explain, this is Article 4, Sections 1 and 2, I think. I'm a little bit hazy on that right now, but I do talk about that in my classes. It says that each state is obligated to give full faith and credit to the acts, records, and judicial proceedings of every other state. So the idea was we all have to work together and we all have to recognize what every other state is doing as legitimate.
Yeah. I think like the best example I've had a teacher give me for that is, let's say, also I'm from Florida, so like I think there are some maybe questionable or maybe a little more radical policies that I see coming out of Florida. And we could use Texas maybe as another example. But obviously not every state is going to agree on every issue, but a good example is let's say two men decide to get married in the state of, I don't know, Colorado, and they come to Florida. I don't know if gay marriage is actually legal there or not, but regardless, the state of Florida has to acknowledge, yes, these two men are in fact married. And I think that has saved a lot. I understand why the founders would implement that after watching the Civil War and why that would be so important to include in the Constitution for its success.
Okay, well, and also just to clarify, the Supreme Court in 2015 essentially said that same-sex marriage is a 14th Amendment issue, and so it is legal in all 50 states.
Yeah, I was just trying to give an example.
But no, you're right. No, you're absolutely right, because before that, it was a major source of controversy. You have that full faith and credit clause, and yet prior to that court decision, you had some states legalizing same-sex marriage and other states prohibiting same-sex marriage, which they can still, well, no, they can't do that now, but which they were able to do at that point. But then that full faith and credit clause essentially, in theory, said if someone, if a same-sex couple gets married in a state that allows it and then moves to a state that doesn't allow it, that state, in theory, would still have to recognize it. And many of those states said, no, we're not going to recognize it. So you had that bit of tension there between the full faith and credit clause and states that effectively said they weren't going to recognize that part of the Constitution.
Yeah, and then sort of tying the two topics together, what you two were discussing, what was previously being discussed between you two, is that all this is it can be argued that it's affected way too much by the personal opinions of the Supreme Court. Because, for example, obviously, gay marriage entered the Supreme Court about roughly a decade ago. That was a huge deal. And obviously there were some judges who were against it, some who were for it. But even regardless of how intelligent they are, how their qualifications, some degree of bias is going to come in. And that bias, the importance of that varies from case to case. But for matters as personal as marriage, I feel like it's that we should take note of the fact that the people in charge of the supreme law of the land are still people. They're still open to flaws, and we should be maybe not fearful, but we should be careful of that.
Okay, recognizing that, if I please correct me if I misunderstand you, but you're essentially saying recognizing that this government, no matter how well designed it is being run by humans, and we have to take that into consideration.
Yes.
Okay. Yeah.
Yeah, speaking about the courts, of course, also another debate that we're having, in today's, I guess, culture is should we reform the Supreme Court? I think we haven't seen, at least to my knowledge, we haven't seen a level of, let's just say, partisan sort of tendencies in the Supreme Court until really now. As we all know, the courts has a conservative sort of power, and while there is an aspect, with it being, with judges being put into the courts by presidents, so of course there's going to be a bit of a sort of party bias or progressive or conservative bias there. I don't think we've seen such a big one until now, where we get things like Roe v. Wade being repealed, which is a really big issue nowadays because of what the former president did. Put in was it two conservative judges? Three judges, and a lot of people argue that maybe there might be term limits. Some say, I think, 18, 20 years of term limit. And I don't know, I think we haven't really seen this level of corruption in the courts before. And they're really powerful. We say checks and balances, but the courts have, in my opinion, a lot more power compared to the other, compared to Congress and the presidential branch. So I think we're at a time where it gets really murky, and we might want to look at reform for the courts.
Well, you raise an interesting point, because the framers thought the judicial branch, and they actually said this in the Federalist Papers, would be the least dangerous branch, because all they do is try to settle disputes. They don't act, they react. They don't act in and of themselves. They can't issue judicial orders. They can only take a case and try and resolve it. Okay? But we now know that that has tremendous consequences. And just to clarify, what you were talking about is the Dobbs decision that effectively overturned Roe versus Wade. And that was at a time when most people suggested that Roe versus Wade was settled, because it had been the law of the land, a judicial decision, for about 50 years. And then a different composition on the Supreme Court, many of whom in their nomination hearings had actually said, well, Roe versus Wade is settled law. They actually talked about its term, not just that it's precedent, super precedent. Yes, exactly. They actually talked about the term super precedent, something that is so established that it seemingly can't be touched. And yet those same justices voted to very quickly then voted to overturn Roe versus Wade.
And that's sort of like the issues that since it was never ratified in the Constitution, Congress never voted on it, got a 2/3 majority. That's what we now know, the fragility of the Supreme Court cases, that if a lot of judges die or retire, and a really conservative or a really liberal president puts in a majority justice, then things can change drastically, and that's in my opinion, a sort of oversight of the Constitution.
Well, one thing I will point out, historically, yes, that is the case, but it is also true that justices can and have changed over time. Probably the most noteworthy example was the appointment of Earl Warren as Chief Justice in the 1950s. Dwight Eisenhower, a Republican, moderate to conservative Republican president, appointed Earl Warren to head up the Supreme Court, thinking that he would be a moderate to conservative justice. And he turned out to be one of the most activist liberal justices we've ever had, to the point where we talk about an entire era of the Supreme Court as the Warren era. And that was the era of the expansion of many, many rights in the Bill of Rights that we still see today. And so they can and do change over time. By the way, that was, I believe, if I'm correct, the famous phrase from Dwight Eisenhower after Earl Warren, after it became obvious how Earl Warren was going to behave on the Supreme Court. Dwight Eisenhower described it as, quote unquote, the biggest damn fool mistake I ever made. So, but Supreme Court justices can change. Now, the justices we're talking about now, the three most recent ones, haven't changed yet. They could, maybe not.
I was gonna say, it's like, because this is a debate I have with myself. I don't know whether, because I understand why the justices are not really bound to any political thing. They're on their own, so that they are not bound to, like thinking about re-election or anything like that. But it's also, they're not really bound to the will of the people, and that's kind of what everyone feels that this country should be founded on, at least.
Yeah, no, that's very, very true, and it's something I talk about in my classes as well. The judicial branch of the federal government or state governments are deliberately anti-democratic. They are not based on the will of the people, and that was actually a deliberate design of the framers, part of that pendulum that I was talking about before, so that it wasn't pushing all the way back towards the Articles of Confederation, where everything was voted on, at the local level. But yes, the judicial branch is not a democratic branch. It doesn't have to respond to the will of the people. Although I will say, there has been research in the past that has suggested that the Supreme Court and the federal courts actually do, maybe with a lag time, they actually do follow public opinion to at least some extent. And there are some famous court cases that we can get into if we have time. But in other words, it's not a built-in and obvious connection to the public, but in a sense, as with that commerce definition that I mentioned before, it's sort of a situation where they kind of see the handwriting on the wall, or they get the idea of what the public wants, and they will change based on that. It's not guaranteed, and again, it's definitely not a feature of the judicial branch. But there is actually some research to show that it happens at least sometimes.
The only one that I was going to bring up is yes, there is a more conservative lean on the Supreme Court, but I think a party affiliation, because of the point that you just made about them not necessarily being bent to any particular will, doesn't mean that just because you're affiliated with the party does not mean that you're going to align all of your policies and stances on a particular issue, for example. And being that Supreme Court justices are there their entire lifetime, they do change, some more so than other. I was gonna bring up the Warren Court, literally racial desegregation and bringing rights or for the undefended. So it's this has happened before, and actually it's happened in the opposite direction too. So I don't know why, but the idea of pendulum, Dr. Cavalli said something about it last year, and it's almost in every situation that we can see in American politics. That's the entire point of these checks and balances. It's whenever we feel one branch is getting too much power, there is the ability for another branch to come in and stop them or say something. And so, I don't know.
Whether they will or not is another thing. That gets back to the idea that we're run by people, but they can.
Yes.
It's just, one thing I wonder is other than just appointing judges, what can the other branches even really do to the Supreme Court?
Well, technically, there are a few things. There are some things that have never been done or haven't been done in a long time. The Congress can impeach and remove Court justices. They haven't done that with the Supreme Court, but there have been federal court judges that have been impeached and removed. So they can do that. They can change their salary. They can change their funding. Again, things they can do but haven't necessarily done. The size of the Supreme Court. This was that whole Commerce Clause thing that I was talking about. Part of what convinced the Supreme Court to change its mind was Franklin Roosevelt's court packing scheme, which did not sit well with the public, but it kind of resonated with the court itself. The court packing scheme, which was not very popular, was Roosevelt's plan to pack the court, to put enough justices on the court that agreed with him to sustain his New Deal policies. He had the Congress. Congress was supportive of what he was doing. They were all his people. But the courts were not. They were striking down a lot of the early New Deal legislation. And so he said, essentially he said, we have a Supreme Court and a bunch of them are getting pretty old. And maybe they're not all there. He didn't say that directly, but that was the implication. They're getting very old and they're not all there. And so maybe what we should do is, since there is no formal limit on the number of Supreme Court justices, it can be any number, it's usually been 9, but it can be any number, he proposed for every justice over the age of 70 that does not step down, the president will have the ability to appoint an additional justice. Okay? And it just so happened, purely by coincidence, that if that were to be put into effect at that time with Roosevelt as president, he would be able to appoint just enough additional justices to have a majority of his supporters on the Supreme Court. And so, again, people saw through it, and it never went over well, but the Supreme Court was actually affected by all the discussion and the controversy, and it seemed to sway their thinking about what commerce meant, so that they took a much broader view of commerce, which empowered the federal government much, much more, allowed much, much more of the Roosevelt's New Deal legislation to stand, and greatly empowered the federal government. And so there have been things that can be done, again, not necessarily, oh, Congress is going to pass a law that says this or that, but kind of nudging the courts in different directions. Others? Does that end it? Have we run out of? Well, we actually, we're just getting. You want to start maybe summarizing a little bit? We are getting a little bit close to the end. So.
Okay, so I'll start wrapping up a little bit. An interesting thing is, I don't know if you guys have seen like the musical Hamilton or anything, but whenever I talk about the Constitution, I like to think the fact of these guys are pretty close to our age, and they were able to write a document that impacted generations upon generations. So imagine what you can do. All right, y'all have a great rest of your day. I'll see you next week. I thought Steven was going to be here to begin with.